And we're talking, a lot of the testimony here concerns what was found in the squad car where the struggle occurred, that's squad 320 if you hear that terminology, and also what was found in the Mercedes where Mr. Floyd was initially found and arrested. We know 2 other people were in the car as well. So let's talk about it, the importance of all of this, and previous testimony as well, as we welcome back our expert panel. They are the best in the business. Let's introduce them to you. Once again, we have our HLN legal analyst, great criminal defense attorney, Joey Jackson. Trial correspondent, attorney yourself, Jean Casares, our law enforcement expert, Darren Porcher's with us, as is death investigator, professor, Jacksonville State University, Joseph Scott Morgan. Reba Martin's with us, HLN legal analyst, great attorney. Bob Bianchi joins us, former prosecutor, defense attorney, and Dr. Priya Banerjee joins us as well. She's a pathologist. So we'll hit this. First off, let's talk about the importance of this. And Darren Porcher, let me go to you as law enforcement, because I'm sure our viewers are going, how do you miss this? A case like this, how do you miss what could be potential evidence? Now, we heard from Mackenzie Anderson saying she didn't know that she was looking for any kind of pill. Is that explanation good for you?
Not even close. This amplifies incompetence. When we look at a case of this magnitude, the assessment of the vehicle or the lab assessment, this should be overly comprehensive. We have a death in custody, and I just refer back to my experience in the NYPD. Whenever there was a death in custody or police shooting, there was an extensive, an overly extensive investigation. For you to miss material evidence inside of the vehicle, it really begs the question of who was the overall supervisor in this? You know, what quality control mechanism was in place? Because this is something that should not have been missed. This is amateur hour at its best.
Wow, strong words there from Darren. Jean, let's go over the timeline here so we know what happened. It was May 25th. The initial search of both vehicles, we're talking about the squad car and the Mercedes, is May. No drugs found. And then what we find on second search of the Mercedes in December, that's where fentanyl and meth are found. And the squad car, that's not searched again until January. What's found there?
Well, I agree with Darren. This is really astounding, especially even the blood, because they're trained to see stains that presumptively could be blood. But there were quite a few number of pills or partially chewed pills with ragged edges. They were still there, so that's the good thing. And remember, this is because the defense had gotten to view the car. They saw it, so they asked for a second search in January. So they saw that, so they did that in January, but also that's when she also saw and tested presumptively 8 different samples of blood. One she didn't do a presumptive test on, but it turned out to be George Floyd's blood. And that could have been important because, hypothetically speaking, what if the law enforcement officers had caused that blood to come out of his mouth? You know, you can't say that it's because of George Floyd that the blood is in the car. You don't know.
No, exactly. That's what I was thinking when you were talking about, when we were listening to that testimony. Well, but how much was George Floyd roughed up in that car? You know, you're thinking that as well. Joseph Scott Morgan, as you look at evidence as a death investigator, to not find it in May and then then you don't find it until December or January, how does that impact things?
It draws into question your professional integrity. And I teach this over and over and over again to my forensic science students at Jacksonville State. What you do in that moment in time, this is your only job, all right? Going back to what Darren had said, this is your only job. This is your sole focus. You have to be laser focused in this moment, because if you have to go back, particularly for something that is so very obvious, I don't know if they can put that image back up on the screen, but that one circle that she drew there with that pill that was identified kind of stands out, doesn't it? So, you know, it even begs a question from a layperson. How do you miss that? How do you miss it? Hey, you know, what else did you have on your plate at that particular time that would have drawn your eye to another location? And then the implication, you know, defense even brought this up. The implication was, is there any indication that the defense could have planted this? Now, I'm paraphrasing right there, but remember, he said that earlier with the investigator, and it really, really clouds the topic here.
Got it. Joey Jackson, so with all of that said, how does this impact the case?
So let me depart from my esteemed and distinguished colleagues in the following way. Of course, in any case, you want to be thorough. You want to ensure that everything is processed. You want to process the scene. You want to dot your I's. You want to cross your T's. But last I checked, George Floyd was not killed within that car. So I would, if I'm a prosecutor, let's focus on what we need to focus on. Anybody ever play three-card monte? Watch here. Here you go. It's over here. It's over here. It's over here. No. What I want you to focus on, ladies and gentlemen, the defense would like to talk to you about a Mercedes. They'd like to talk to you about when drugs were found and not found. They'd like to talk to you about what was processed and what's not, and its amateur hour, and A and B and C and D. Let's talk about what happened here. What happened here relates to an objectively unreasonable use of force. Yes, we would have liked, ladies and gentlemen, to process the car, but what was the focus of the car? What was the car other than the fact that George Floyd was pulled out of that car, other than the fact that the officers approached the car and were throwing F-bombs at him at the time and disrespecting him and showing him no humanity whatsoever? He could have been gum on someone's shoe. What I want you to look at, ladies and gentlemen, are the critical facts, the things we have to prove to you as it relates to cause of death. Are we going to find that in the Mercedes? As it relates to what a use of force is and how proper, are we going to find that in the Mercedes? I want you to look at what the police did and didn't do, and what they didn't do was show him any humanity. That's why he's dead, and that's why he's guilty. So yes, of course you want to process a scene. Of course police should be perfect, and everyone should do everything perfect. And if I was on my defense side, that's what I'd be saying. But from a prosecution perspective, come on. This is about what happened on the street. Let's look at that.
Got it. And Areva Martin, because the prosecution, they do not deny that there were drugs in George Floyd's system, correct?
No, they're not going to deny that. And what's going to happen is jurors are going to use their common sense as they make, as they move through the deliberation process with respect to this case. And we heard the defense bring out the extensive nature of the investigation that was done with respect to this case. The thousands of pages of documents, the excessive number of people that were involved in this investigation. So people, I think, are going to give, in this case, the jurors are going to give the prosecution some leeway. They are not going to hold the prosecution accountable for the acts of every single law enforcement agent that was involved in the investigation of this case. And I think that's going to be the prosecution's job, is to keep reminding the jurors, what did you see in that videotape? How unusual it was that these 10 or 12 bystanders come upon a scene and see four, and what we heard today, not just 4 officers, but 5 officers at an incident, 3 of them using their body weight to hold down George Floyd as these bystanders continue to plead for his life, continue to plead that they provide medical care. So the prosecutors are going to have to keep taking the jurors back to the essential elements of this case. Was the force used by Chauvin unreasonable? Was it excessive? Was it illegal? And we heard outstanding testimony this morning from Jody Steiger establishing that the force used was unreasonable, that it was illegal, and that it was excessive. So the prosecution just has to keep driving that point home. And overall, again, as I've said many times, Mike, I think jurors connect with the emotional part of this case. Our eyes saw a man get killed on the streets of Minneapolis, something that people have never probably witnessed in their entire lives. That's going to stick with these jurors, and I think that's going to carry the day.
No, I think that's such a great point, Areva, that the prosecution, again, to that testimony that Jody Steiger testified, the force here was deadly force. That's what the prosecution has to hammer home. But, Bob Bianchi, if you're the defense, now you have something to work with, and this investigation, some would say, was sloppy. How do you argue this before a jury?
I just, as a former homicide prosecutor, this is testimony I do not want to come out. You have to remember, Mike, that this car is a crime scene. That's why it's been shipped off, it's been secured, it's been locked down. And you're right to the point. That's the argument you make as a defense attorney. They didn't look because they wanted to come to a conclusion. And the use of that force expert gets up and says it was an unreasonable use of force, but then gave a number of different scenarios, one of which was the same scenario with Mr. Floyd, and indicated that there could be a potential problem where you have to worry about the crowd coming after you, and you have to have all this situational awareness. So the bottom line with regard to the car is sloppy, sloppy, sloppy. And if I'm sitting there as the prosecutor, I'm taking a dagger to the heart, because the defense attorney is going to say if it was sloppy there, that was because they wanted to put a square peg in a round hole and they didn't care. They seized it, but they didn't properly evaluate it. It took the defense to do that. This is just not the way to go forward with the prosecution. It hurts them substantively throughout the whole case because it is sloppy.
Got it. All right, so we can expect a cross-examination to come. Joey, play the role of defense attorney. You're cross-examining this witness concerning this investigation. What's your line of fire?
Oh, my other hat? Okay, before I was the prosecutor saying they keep your eye on the prize. It's ridiculous. The defense wants you to talk about what's in the car, what's not in the car. What are you talking about? We're on the street. But now I'm a defense attorney. Now I'm saying you'd agree with me that every investigation's important, right? And in investigations, you want to be exact. Is that right? You want to be accurate. Is that correct? You want to get all the information because everything's relevant. Is that true? You don't want to jump to conclusions. You don't want to unfairly indicate that somebody might be guilty when they're not, right? And that's the importance of being thorough, right? So let's talk about this investigation. You have an obligation to secure that scene. Is that true? And in securing that scene, part of that scene would be the Mercedes, right? It's important for this jury to know exactly what's in the Mercedes.
Right.
And you looked in the Mercedes, you evaluated the Mercedes, etc. So I could continue.
Yes. Well, we're going to find out right now as the cross-examination is about to commence. Let's listen.